Back to the Supreme Court, a decision that's bad for pain patients that no one else seems to be covering is the court ruling against Purdue Pharma. If you've seen my opioid scare playlist, now refreshed in a brand new playlist with additional material as well as linking material, hopefully resulting in things making a lot more sense, you'll know that the Sackler family got the blame for opioid overdoses, even though we know it wasn't pharmaceutical opioids that was causing the issue. It was heroin and later fentanyl on the black market, but an incorrect cause of death was routinely recorded, and the CDC was counting the deaths incorrectly. When the CDC discovered that around 2005 to 2007, instead of correcting the problem, they decided to cover up for it by hiring a PR firm. And everything everyone thinks they know about the opioid crisis comes from this PR firm, not from any scientific studies or data. Now, I'm not saying the Sackler family doesn't deserve to go bankrupt. They were doing some things with their money that weren't quite kosher. But what the Supreme Court says has the potential to continue to prolong and even cause suffering for millions of pain patients. The Sacklers had settled a massive lawsuit claiming that OxyContin was resulting in addiction and death, a settlement worth some $8 billion. That was tied into their bankruptcy claim, which the court just invalidated 5-4. Dissenting were Kavanaugh, Roberts, Sotomayor, and Kagan. Yeah, the conservative justices were on the wrong side of this one, overturning the federal court's bankruptcy judgment for basically no reason other than drugs bad. That means that it's open season for lawsuit against the Sacklers from individuals and state governments alike. Kavanaugh wrote, "Today's decision is wrong on the law and devastating for more than 100,000 opioid victims and their families. The court's decision rewrites the text of the U.S. Bankruptcy Code and restricts the long-established authority of bankruptcy courts to fashion fair and equitable relief for mass tort victims. As a result, opioid victims are now deprived of the substantial monetary recovery that they long fought for and finally secured after years of litigation." What he doesn't mention but should have is, it's potentially devastating for pain patients. In fact, they don't get a mention anywhere in the judgment or the dissent. In fact, it's hard to find anyone this decision is good for other than ambulance-chasing lawyers. The lawsuit was brought by state attorneys general, with some scattered individuals to give their sob stories and spew their hysteria, such as Eddie Bish, who died from an overdose supposedly of OxyContin, but since we are among the few who know that these deaths aren't being recorded correctly, it's far more likely it was either a black market opioid or polypharmacology, taking 2 or more drugs that interact badly, such as taking OxyContin and drinking alcohol. In the words of Crystal Lindell of Pain News Network, quote, "The High Court's ruling means the Sackler family is now open to more lawsuits against it, and that some of the previously decided opioid cases could now be reopened. That's not just bad for those slated to receive money from these lawsuits, it's also bad for pain patients. Continuing the opioid lawsuits will only perpetuate the anti-opioid zealotry that's infiltrated the medical community." The Supreme Court's decision, and by extension all of the future lawsuits, are just going to perpetuate the myth that Purdue did a horrible thing when they claimed, truthfully, that OxyContin wasn't as addictive as other opioids. In fact, Purdue's lie wasn't about how addictive it was, because that was absolutely true. No, their lie, which no one else except PNN is pointing out, is that they claimed OxyContin will last 12 hours, when it does good to last 6. That's been confirmed by outlets such as the Los Angeles Times. I can tell you firsthand that hydrocodone and oxycodone are supposed to last 6, but they barely last 2.5 to 3. My pain specialist confirmed to me that's generally the case for many patients, and the experience of many people posting to pain management forums says the same thing. So what this means is that patients aren't prescribed enough pills to get through the day, meaning that either you suffer more every day than you have to, or you take additional pills to properly get your pain levels down, but they don't last the month. And in the meantime, since you're taking the pills in a manner inconsistent with the label, that's legally considered drug abuse. And they wonder why many pain patients resort to the black market. Purdue was aware of this, but in order to maintain the lie that their formulation lasted 12 hours, they told doctors to stick to the 12-hour schedule and prescribe higher doses instead. What doctors should be doing is prescribing more pills of a lower dosage, but what they've learned to do, and what they're now being demanded to do by lawsuits, is to completely minimize the amount of opioids prescribed. Purdue was even responsible for one of the big revolutions in pain management, the routine recording of pain levels. This elevated pain from something doctors dismissed as just a part of disease to a fifth vital sign that was crucial to the well-being of the patient. Ever since that happened, the anti-opioid zealots have been working to reverse it. And now, it's only going to get worse. Lindell wrote, "Maybe one day we will finally realize just how damaging it has been to make people suffer needlessly by limiting opioid prescriptions. But I fear that as long as the opioid lawsuits continue, that day will be pushed further and further out into the future." Remember, opioids are the only genuine painkiller on the market. There just is no other option. So the literal torture of pain patients will reprehensibly continue.